Good day, friends. You're watching Tax Dosti videos, and we are in the final video regarding the judgment by Sindh High Court that the tax imposed under Section 7E of Income Tax Ordinance 2001 for tax year 2022 and 23 and onwards is a valid tax. Neither is it discriminatory, meaning that it applies to a separate class of people and all the people in that class are treated equally. Neither is it confiscatory, meaning that the burden of tax that it imposes is in accordance with the income and assets of the taxpayer. And thirdly, the conclusion they have reached is third conclusion is that the federal government has the legislative power to implement such law, and for that they have used entry number 47 of fourth schedule, which is taxes on income, which is given in the Constitution of 1973. We'll wrap up in this video. In previous videos, every paragraph had its video, so we have made 14 videos previously. You can watch it, and basically everyone is titled Section 7E, and we will wind up section paragraph 15 to 20 in this video. So the judge says that from the above observation and conclusion, it is clearly reflects that any reliance by the petitioners on paragraph 31 and etc. in support of their respective contention not in accordance with what has been finally held by the Honorable Supreme Court. So basically in this Sindh High Court judgment, the judges have relied heavily on the judgment of the Ilahi Cotton 1997, and where deemed income, deemed tax has been approved by the Supreme Court. So the judge is convinced that the petitioners have not made their case. On the other hand, in fact, it is the inverse and supports the case of the as to validity of the impugned levy. And the following observation of on that the law should be saved rather than destroyed, that as per dictionary word income means a thing that comes in, that the expression income includes not merely what is received or what comes in by exploiting the use of property, but also what one saves by using it on oneself. So this is, for example, use of house by its owner. So this is the main premise, this is the main reason the Sindh High Court judges, honorable judges, have said that even if a person holding immovable property more than 25 million as at 30th June 2022, and then for every tax year, even if he holds the property and has not let them out or is not earning any actual income, having multiple homes, multiple offices saves him money, and that saving is also a kind of deemed income, and it has been taxed under Section 7E. And that what is not income under income tax can be made income by a finance act. That generally the fact. These are conclusions of different Supreme Court cases of Pakistan and India, where regarding tax Supreme Court has held these principles, that when a statute enacts that something shall be deemed to have been done, which in fact and is in truth was not done, the court is entitled and bound to ascertain for what purpose and between what person the statutory fiction is to be resorted to. So the court will decide, and the court has decided that this section applies on people who hold property, especially immobile property, as of 30th June 2022, more than 25 millions, and they have to pay tax at 1% of the fair market value of those properties. Every resident person has to do this. Paragraph 16 says that therefore, as far as the concept of deemed income is concerned, it is not in dispute that it is an approved concept of taxation, meaning that in Ilahi Cotton and subsequently after 1997, many judgments of Supreme Court and Honorable High Courts have approved the concept of taxation of deemed income. Deemed income means an income which you do not actually receive, but the government says that you have received such and such income. For example, living in your own home, you have saved rent. This saving of rent is income, and this can be taxed. But here, basically, instead of taxing saved rental income, which may be disputed or confused with income from property, rental income, they have taxed the as a tax base the value of the immobile property, especially plots and things that people hold and cannot give on rent or cannot lease, but still it appreciates in value. And since it appreciates in value, and people maybe may not pay proper capital gain tax, so government is anticipating, keeping in mind anti avoidance of these taxes, it has proactively applied section 7E, which is taxing the properties, and this comes under entry 47 of the federal legislative list, meaning that the federation has the power, and holding of property beyond the threshold 25 million is the threshold as provided under section 7E2G is by itself a transaction which has to be deemed to be income within the ambit of 7E, meaning that holding of property is also a transaction legally, and it can be taxed because since it's a transaction. The argument that only occurs when an actual amount of income has been received is also misconceived, as we can see in the Honorable Supreme Court's Elahi Cotton case, that even if we do not actually receive income, still it can be taxed, just as you are taxed on your mobile recharge. Now, mobile recharge for you is an expense, but it has become a fictional income, and that fictional income is then taxed. And if at all it is to be relatable to actual transaction or attempt to generate an income as contended, it would then be an income deemed to have arisen. Now, a very good distinction has been made between fictional income and deemed income. Sometimes deemed income is actual income, and fictional income in this case is income that you will never receive. But deemed income sometimes can be income which you receive after a few years, but it is taxed now. This is what the concept of deemed income is. Any other interpretation meaning would be not be deemed income but as actual income. It is income which is deemed to have arisen at all. So, in fact, by way of insertion of section, another head of income has been created, though fictionally. So, the judge has gone on to say that along with the heads of income of salary, income from business, income from property, income from other sources, and capital gains head, another head of income has been created, which is holding of property of a certain value. Now, fictions always conflict with reality, whereas a presumption may prove to be true. Legal fictions create an artificial state of affair by a mandate of the legislation, meaning that the law can create a circumstances for you, meaning that section 7E is saying that if you hold a property of more than 25 million, you are considered to have earned income of 1% of its fair market value for that year. Paragraph 17 says, once the petition counsel had relied upon case of PIDC in support of contention that the concept of deemed income has not been approved by Honorable Supreme Court, however, this contention is misconceived as much as in the case of Elahi Cotton. Elahi Cotton case proves that deemed income is also a tax concept, and here this is not before us, hence any passing remarks in case will not be relevant. So they have refrained from giving comments on other cases. PIDC one, I'll just read this quote from our favorite Palkiwala Saab, the Indian legendary tax lawyer, and his Income Tax Volume 1, 8th edition. It was further worded, thus the phrase deemed to accrue or arise to him in India during such years, and the corresponding phrase with reference to receipt in this section involves our possible concept of artificial accrual or receipt, artificial place of accrual or receipt, artificial chargeability of person other than actual owner of the income, and artificial year of taxability. So Palkiwala Saab has qualified or has quantified the different scenarios where deemed income can be considered, and in 18th chapter the judges are about to conclude, and I'll read the second last paragraph. Lastly, an agreement was also made as to the inability of FBR to make arrangements to collect the imputed levy, as no modalities have been made public. So a last request at declaring section 7E as invalid was made by saying that there is no procedures, but this does not matter, as the judge says, because without even procedures still the government has the right, it's competent, and it is imposing a fair tax on people holding property. Paragraph number 20 and the last paragraph on page 30 says, from pursuit of above cases law as well as dictum laid down by the Honorable Supreme Court in the case of Ilahi Cotton, and in view of henceforth facts and circumstances, after hearing everyone, it is no exception can be drawn to the competence of federal legislation while introducing section 7E or through Finance Act 2022. So federal legislation has the power to tax income, and income includes the concept of deemed income as well as fictitious income, nor is it confiscatory or discriminatory. Neither it is putting too much unfair burden on the taxpayer, and neither are some taxpayer being taxed while other are not. The similar group of taxpayers, for example those having assets of more than 25 million, are being taxed, all of them. Federal legislation is fully competent to impose tax on deemed income, and the petitions are dismissed, meaning the petitioner had requested the court to overturn or strike down this law. The court has not done so. You were watching Sindh High Court judgment, which was given in October 2022 regarding the validity of section 7E, and judgment was given by Mr. Justice Muhammad Junaid, Mr. Justice Agha in the High Court of Sindh, and there were many petitioners, and even those people who had not petitioned the Sindh High Court, still they would have gotten the benefit if the court had ruled in the favor that section 7E is invalid. The date of hearing and order was 28th of October 2022. You're watching Tax Dosti videos. I am your tax host and tax dost, Anthony Williams, and this concludes our series on 15-part series on this recent judgment. Now when Lahore High Court gives its judgment, we will discuss what they have said. Is section 7E, tax on deemed income, valid or invalid? See you in the next video. Thank you very much.